I think he should come down. I thought he was coming with his eye.
Keep going.
Is he back? Is he back? Oh, yeah. Okay, because I thought he went back to Florida. I said, he called me on yesterday. Okay, he's back. Mister?
Good afternoon, Your Honor. May it please this honorable court, I am David Mister, with Mr. Winter and Bartlett, and along with Amy Finneran, who's at appellate's counsel table, who's co-author of the brief. We represent the appellates here today. It's the appellant's contention that under the current state alcoholic beverages law, as applicable in Baltimore County, the appellant could present the Rolling Stones performing on the patio prior to 11 p.m. and not be subject to any current lawful prior restraint by the Baltimore County Liquor Board on the presentation or place of such musical performance.
So your position is the only available sanctions would be, if it were a violation, to fine, suspend, or revoke?
That's correct, Your Honor. And the fine would have to be limited to $2,000 per violation and or a suspension or revocation of the license privilege. And that's really the crux of our argument.
And it would have to be after the presentation of the Rolling Stones.
That's exactly correct.
Okay.
Because I think Baltimore County relies in their brief and obviously at the circuit court level, and it seems apparent from the decision taken by the Liquor Board that they were sanctioning based upon what they found to be a disturbance to the public peace or a disturbance to some of the neighbors, which they deemed, it seems in their holding, to be.
And this is outside of any police powers to, I mean, in the sense of outside of the Liquor Board, obviously the police would have some authority to do something if the neighbors kept reporting a disturbance.
There certainly could be criminal sanctions, there could be criminal investigations, there could be criminal charges brought, obviously with a due process hearing. There could be, and as a matter of fact, it's alluded to in the transcript, there could be zoning issues that arise, but this was a Liquor Board proceeding, and they were given notice to come in and show cause while they shouldn't be held in violation because of disturbance to the neighbors. And it's the Liquor Board that was making that decision.
As a purely either jurisdictional or a power-granting issue, could they refuse to renew your client's license for this reason?
Well, there's a procedure to go through where up to, not up to, at least 10 citizens
right. I'm familiar with
annually
that.
might do that, may raise any kind of issues. The board then has to conduct a hearing before the beginning of the new license year and make a decision as to whether it would be appropriate to renew the license. So I believe that the way this was postured, it would have been a determination to essentially revoke the license. However, if it was done in the process where appropriate complaints of the critical mass, if I might add, by usually citizens are made, the board could consider it in that context. Yes, they could. And probably would be in a completely different posture had it happened that way. And while it probably doesn't make me feel warm and fuzzy that the board could do it, had the board imposed a sanction, a greater fine, or even a suspension, or, God forbid, a revocation, we may not be here today. The problem that we disputed, and I think we've admitted in our earlier proceedings and before the circuit court as well as in our brief, that really we don't dispute the fine. And in fact, the board had the right to impose the fine because it was less than that allowed by statute. The board made certain findings. We don't really dispute that there was substantial evidence in the record to support a finding that the licensee may have in fact been in violation of a board rule or the State Alcoholic Beverages Code as regards potential disturbance to the public peace and the like.
Can a liquor board, in granting a license, impose a restriction on live music in a given situation?
Well, in a given situation, but not in Baltimore County. As some of this court may be aware, the state alcoholic beverages code is complex. I think it's rather anachronistic. Its application is idiosyncratic, and different counties, by virtue of adding additional local provisions on or amendments to the general law, provide themselves with that. I've cited in my brief favorably, for instance, in Baltimore City, there is a special license privilege. It's granted for entertainment purposes, and it's actually a two-tier type of license. In Anne Arundel County, they specifically, by General Assembly enactment, both of these would be, Baltimore City, Anne Arundel County, provide for a music and dancing type of license, which is distinct from licenses that may be granted to those who don't have music and dancing.
I think I've been reliably informed that a retired judge of the Court of Special Appeals has been asked by the Code Revision Committee to undertake a code revision of Article 2B, which I'm less than sanguine will solve all of these little idiosyncratic problems.
Judge Harrell, I'm less than sanguine. Also, some of my friends who have served in the Maryland General Assembly, some that are still there, have regaled me at times over the years of prior attempts to revise the code so as to make it uniform and the like. And it appears that there's a lot of political issues that come up in that, where people may not necessarily want to give up some of their local prerogatives.
So the long and the short of it, with regard to Baltimore County and a liquor license, the sanction here was restriction of live music, wasn't it?
It was restriction, and actually it was a little bit less than that, or more specific to that.
Outside music.
Outside music,
okay.
Either presented outside or potentially piped outside.
Okay.
Was there a question when that came up that way, addressed to the board, and said, "What do you mean by outside music? If we got some guy with a guitar outside there, is that outside music? If we got a box in the window that's blaring out there, is that outside music?"
Well, there was. The Chairman Mencken, who happens to be a very experienced attorney, the chairman of the liquor board, a question was posed from the audience, and the court reporter didn't know who it was, I don't believe, and it's in the transcript. And
I thought he just sort of, apropos of our zoning case earlier this morning, said, govern yourself with the principles, views.
Exactly what he said. Let your conscience be your guide when it comes to what you should do, etc. But he did, I think, make it rather clear that he intended it to apply to the actual presentation of music outside, where presumably the performers would be outside, or piping it out somehow, which, I think that, that wasn't our real concern on that, as to whether they were doing it somehow electronically or loudspeaker or opening the windows and letting it flow out. Our concern was, of course, that they said, absolutely none. You can't do it. And we find that's not an appropriate sanction under the law as of State of Maryland, applicable in Baltimore County, because it would require both an enabling statute, which did not exist. At least, I know the county disagrees on this, but the enabling statute they refer to doesn't really authorize the liquor board to adopt a rule that says total prohibition of music.
But it does reach mechanical boxes, right?
It does authorize the regulation of mechanical boxes and basically the mechanical production of music. And then Baltimore County actually then adopted a rule that says you can't present any of that type of music after 11 p.m. at night unless it's going to be reasonably confined within a building so it can't disturb the peace. Well, the problem here, they then came back with a sanction and said, you can't do it ever. And that was clear when there was a dialogue between Chairman Mencken and somebody in the audience, one of the protestants, I would add, from my experience being there, that, what do you mean? When is this going to be, Mr. Chairman, so to speak, to paraphrase? And not at all. And it was indefinite. And that's the problem. And, of course, the evidence in the record, we mentioned it briefly, was that this musical presentation was between 4 p.m. and 8 p.m. on that particular Sunday that they complained about. It was only one date that the neighbors had come and complained about.
If we were to agree with you that the board lacked the power to impose this restriction, and we sent the case, we remanded the case, and it went again before the liquor board, could they then revoke your license?
Well, First thing I will address is whether or not this court could remand the case. Because under 2B, Section 16101, there's only 9 jurisdictions in which the courts can remand back to the board, and Baltimore County is not one of them. So this court's authority is limited to a reversal, an affirmance, or a modification of the liquor board's order. And of course, we urge on you that you either reverse it with regard to the issue of the...
Do you mean we could modify it and say it's revoked?
You know what? I contemplate the court could ask that question. I would hope that that would not be deemed an appropriate sanction by this court, but I suppose that...
Are you saying we have that power?
It appears that the statute, the General Assembly gave that kind of broad powers to the appellate reviewing courts, whether it be the circuit court or the higher appellate courts, when they said that they could affirm, reverse, or modify. And in cases of the 9 other circuit courts, they can also remand.
So we could send it back and say, it's okay for you to do what you do as long as you don't hire a band called the Mechanical Boxes.
Well, it's interesting you say that. I did want to build on that. I made a mention in the brief, probably only as a footnote, but it's our contention that if we presented the Morgan State Choir to sing a cappella without any mechanical music, or even a larger choir.
We could have an organ grinder, I guess, because it's
the
not
Mormon
a mechanical
Tabernacle.
box.
That is not even covered by the current rule of the board or the enabling legislation from the General Assembly, because that would not be the production of music by a mechanical box.
So that means then what? There could not be such a limitation imposed on the license?
That's correct, unless there's new legislation adopted applicable to Baltimore County or, to all counties, which did provide for that. And that's the real concern here. The whole history of the development of alcoholic beverages law, and there's cases, one of which Judge Murphy authored in the Baines case, which have always said the board's...
Murph's Tabernacle was the name of that bar. I remember it.
The board's power...
Murph's Tabernacle. Tabernacle.
Really?
Tabernacle.
He is very creative.
The board's powers are limited to those granted to them by the
No
General
relation.
Assembly, strictly. And that's the problem we have. The county's argument would be, because of this general legislation saying you can regulate music and you can, particularly by mechanical boxes, et cetera, the county suggests that that gives the board some sort of ad hoc power to, on a case-by-case basis, say, you know what, you can't do anything. You're sanctioned to do that. And,
Would your client need another kind of a license to present outdoor, say, live entertainment?
Not under the current law in Baltimore County. As I said, as I cited in our brief, Anne Arundel and Baltimore City are 2 that may not be exhaustive. There may be a few other counties that do that, but they specifically come to mind, and I'm aware of those particular licenses. It's a separate determination by the board, and they give them a separate permit as part of, or separate license for that. It specifically says, endorsed right on the license, what those privileges are. Baltimore County does not do that. They have never had a separate regulatory scheme for any kind of entertainment or music or whatever. Now, I don't speak to the issue of what the zoning code may say in Baltimore County about certain types of things and where they can be presented and under what in what locations and what the requisite zoning is.
Could the board, in fashioning a remedy, say something to the effect that any outdoor activity associated with this license must comply with all of the other provisions in the Baltimore County Code that pertains to outdoor activity?
Well, I think that's already the law. I think that would be redundant because the Alcoholic Beverages Code does make reference to the fact that there must be appropriate zoning for the business before a license should be granted.
Well, that's the issuance of the license, though. I'm talking about the running the business on a day-to-day basis.
Of course, also, there's a separate provision. I know it's cited by the county that in the board's rules that you're supposed to comply with all other laws and ordinances and regulations. And also, of course, things like disturbance of the peace, it's a general law that's there, and they could be sanctioned for that. I think the problem is to impose some sanction that the legislature is not authorized is not appropriate. And
It's a preemptive strike, I guess, against...
My other concern is, I know that I will confess it was not appropriately preserved below. Part of it's because I was surprised, to say the least, with Judge Bollinger's opinion in this case. I actually thought this was a pretty clear-cut thing, and I thought we were going to win. You know, it wouldn't be the first time I've been surprised in my 36 years as a trial lawyer. But so we started to think a little bit more innovatively. While perhaps we didn't raise any issue of the constitutionality of what's there, I think it's implicated by the fact that when the legislature goes to look at it, if in fact the county can convince them to adopt some remedial legislation, or the liquor board comes back trying to do some remedial rulemaking, they're going to have to look at it and appropriately abide by the constitutional restrictions to make sure it's a fair and reasonable time, place, and manner regulation, so that it does not, in fact, violate it. And I think any kind of total prohibition, in most cases, unless it would be as a sanction for prior misconduct, would probably be constitutionally impermissible.
Thank you, sir.
Yeah.
Ms. Gaskins?
Good afternoon. It's a pleasure to appear before this court. It's my first time in over 25 years of practice, and it's an honor to appear before you. It is the county's contention that Section 9201, unlike the other cases upon which the appellant has relied on, the Fells Point case and the J.R. Brothers, where they found that the liquor board did not have authority, express authority. In this case, it is the county's contention that the board had express authority under Section 9-201, specifically, that addresses music and other sound-making devices. As a result of that grant of legislative authority, the board promulgated regulations, specifically Rules 3A and 3B, which prohibit musical boxes and other sound-making devices after 11 o'clock. And then in 3B, it prohibits disturbing the peace in general before or after 11 o'clock. And it's the board's contention that it is an appropriate exercise of its authority. It kind of baffles me that licensees, such as Thanner in this case, will argue that, well, if the board had suspended us, we wouldn't be here, or things to that effect. I mean, to think that you'd rather be suspended rather than have a condition imposed on you, to me is sort of baffling.
His argument is that now that you've imposed this restriction, if we agree with him, we can't send it back to the board to reconsider the sanction. Mm-hmm. What's your answer to his argument on that point?
Well, I agree that there are, in general, those three areas or three remedies, but modification, I think that it would allow this court to impose a modification of what the board
So we have to decide what the modification would be?
Well, it's not my position that this court should,
right,
other than just affirmance. I think that based on the authority that has been provided by the legislature and what the board imposed, that it should be affirmed. And I see nothing, no reason why the decision of the board cannot be affirmed in here, because there is that authority. I mean, it's specific. The question is, what effect would what is the purpose of 9201 if it's not to allow boards to impose a ban on musical and other sound-making devices? And if Mr. or Thanner thinks that that's unconstitutional, then comply with those requirements, submit the brief to the Attorney General, and argue that 9201 is unconstitutional. But
The argument, as I understand it, or at least part of the argument, is that the ruling of the Liquor Board prohibits them from having a singer outside who's just going to sing to the people on the deck or whatever it is, even if there's no any kind of amplification, mechanical or otherwise, that they just can't do that. And that, I guess, is the argument that that's an overbroad remedy for the violation proven.
Well, I think, Mr. Mencken did in fact say, let your conscience be your guide. I think if they wanted to bring, Leontine Price or Tammy Wynette to sing a cappella on the deck and test the board's sanction, then it would be up to the board to then have its inspector go out there, and then the board, if it found that there was a violation, bring them back, and then Mr. Thanner could argue his case before the board that he is not in violation of the sanction imposed because there was no musical or sound-making device used, and that they did not disturb the peace. And they do use meters when they go out there, so if the singing did not rise above a certain level, there wouldn't be any violation or sanction or discipline imposed for that.
It might be an easier case for your side of it if the prohibition was against making noise that reached a certain decibel level, as opposed to making any noise at all. I mean, what would happen if some patron, with a snootful, got up and started singing and had a sing-along? No mechanical devices or anything like that. It's just all these people singing the Colt fight song or the Ravens fight song or the Orioles fight song, right? What happens then?
Well, I think then members of the community would have to come in and testify why that was disturbing to them, and if they could say that the walls were rattling, or they could hear it above the air conditioning, like in this case here, then it's for the board to make a factual determination whether they think that it was in fact disturbing. And
if there were complaints from a neighborhood, and just so that I understand, and an inspector goes out and measures, I gather they go out at that time, there's a complaint, and then an inspector goes out, and the inspector says, no, it's below a certain level. It doesn't matter what the complaint is then, right?
I would think probably it would not be, but I can't say that for sure. But I think I don't know.
Because otherwise, why would you have a meter? Because then you just have a complaint, right? I mean, it would mean that any complaint would be a disturbance.
Yeah, I think the meter might sort of confirm that it's disturbing.
Let's just assume that the meter, and again, I gather it's one of those things that goes over and tells you the noise level. If they're limited from all playing, wouldn't the modification be that they can't rise to the level that's the level that you define, that the liquor board defines? Because all music means that even if they used a mechanical device and it was quiet compared to your device, then why is the prohibition of all music appropriate?
Well, I think
because we just determined that not all music is shut down, even if there's a disturbance. I mean, that it has to be that, because every disturbance would make, every complaint would make the end of the music, basically, right?
Right. And I think in this particular case, I think part of it is punitive. I mean, it's a sanction because they did in fact disturb the peace, that they're just going to punish them in in this respect, or impose it as a sanction, as opposed to, I think, what Your Honor is asking, sort of setting a standard for what the noise level is.
Because they already have the standard, you know, with the inspector. The inspector, they have already set some standard. So what concerns me is that if it's punitive, then even though there may be a substantial basis to say that they disturbed the peace on one occasion, do we have any reason to think that the result is arbitrary and capricious?
No, you know, I guess it may not be in the record, but this wasn't the first time, and Mr. Mister can confirm that. You know, and usually in these cases, it's because it's been an ongoing
And that's
problem.
in the record. That's a
Yes,
finding.
and I think it alludes to the fact, I think if you look at Mr. Minkin's decision, where the Councilman Olszewski was involved, because I think the community and the licensees had a meeting, and I'm not sure of the specific facts, but there was a meeting taking place, and because this was an ongoing problem, it wasn't I don't want the court to have the impression that on July 1st, for the very first time, there was noise.
No, I think there's a history to it, and
Yes.
there's certainly that much. But the sanction, I mean, the decision that was on appeal, the August 7, 2007 decisions on page 56 of the joint record extract, and it's, quote, "no more music outside," close quote. Now, that's quite a broad sanction.
Well, again, if they say we're going to revoke your license and you can't practice, or you're out of business, that's pretty strict too.
I agree. I mean, this may be one of these, you know, be careful what you ask for,
That's
because you just
exactly
might
right.
get it.
That's
But,
exactly right. But I think also, to just also address that point, they will come up for renewal. And I think at that time, while it may sound indefinite, and while I'm on that subject, there was a response by Mr. Minkin because of someone from the audience. But that person also asked, does this sanction just run till the end of the year, or is it longer, basically? And Mr. Minkin's response, I think, was addressing the point that, no, it's not just till the end of the year. I mean, somebody just blurted out from the gallery something, and his point was, he said door number 2, and he said it's not just till the end of the year. But when Thanner comes up for renewal, I think the issue is then addressed whether or not they should even be licensed, be issued a license. And in addition, they may look at the issue of whether or not he can then play music again. As a matter of fact, I think, and Mr. Mister can correct me if I'm wrong, subsequent to all this, Mr. Thanner was back before the board, and there were some concessions. And I can't say exactly what they are now, but there were some concessions that Mr. Thanner was willing to make, and so it may be worked out. And there's also another issue going on about whether or not whether or not the business is a nightclub under the zoning that Mr.
what's your take on the authority of this court to send the case back for further proceedings? Do you read anything in the statutes that are applicable here to be a prohibition against this court from directing that the case go back to the circuit court to consider the appropriateness of the extended ban against any music outside, as opposed to the limitations expressly authorized by statute dealing with mechanical boxes?
No, I think this court could send it back to the circuit court.
Circuit Court send it back.
That's, my understanding is it has it could reverse or affirm
And that's
or modify.
because,
It's in the statute. I don't know what statute that is. It may be near 16101.
Okay. I mean, we could send it back, under your interpretation, if we disagreed with Baltimore County, we could reverse the circuit court and remand the case to the liquor board for further proceedings in accordance with whatever opinion we had?
I think it could be remanded back to the circuit court. For the circuit court, I think Judge Murphy was asking if the circuit court could then, I guess, ask for instructions or clarification on the liquor board's decision. I think this court could do that.
I mean, I guess I don't understand that question. I mean, that response, because what would they do? It seems pretty clear to me what the liquor board did here. So what would the circuit court be able to do? I mean, the circuit court, if we reverse the circuit court, then the circuit court wouldn't, what would the circuit court do? Except it would have to remand back to the liquor board.
If we reverse the circuit court,
Yeah.
then can we say to the circuit court, now you take another crack at this, or don't we have to say, send it back to the liquor board?
Or say send it back to the liquor board? No, I don't.
Or say, strike the violation number 2. Or
Yes,
modify
I think you
violation number 2.
I think you could say to the circuit court, well, we find that the fine is, or we remand it, and the fine is legal, or
Well, they're not objecting to that. Yeah.
But the condition is.
Okay. Thank you.
Thank you, sir. All right, Mr.
Thank you, Chief Judge Bell.
What findings are there with reference to this history? Just, you don't have to go through the whole thing, but are there specific findings?
I believe
relative to-
there are not specific findings. That's one of the things we addressed in our brief that we criticized as part of the arbitrary and unreasonable. But while there's some discussion about you, meaning the citizens down there, kind of know what's going on, more of it centers around some things that Chairman Minkin is addressing to the audience, because he knows they've got zoning issues they're dealing with, and that were on appeal at that time either to the Baltimore County Board of Zoning Appeals, which they just called the Baltimore County Board of Appeals, or the Circuit Court. Frankly, I can't remember. I think Chairman Minkin thought it was a Circuit Court. I don't know whether they progressed that far yet, but it was separate counsel, completely separate administrative process that was going through, and is, by the way, at this moment is still ongoing in the appellate process.
If you concede substantial basis, but you claim that it's arbitrary and capricious in terms of the implications or what they do as a sanction, don't we have to know what the basis for their decision was? I mean, in the sense that it's either one or many. There seems to be in terms of the basis. You've already conceded that there's a substantial basis, but there seems to be a difference of opinion as to what the basis is.
Let me address that in multiple parts. Firstly, that the issue of us conceding that there was substantial evidence, we do that, but that's not what the basis of this appeal is. That's only as to the factual determinations they made that there was a violation. And I would agree. We would admit that the Liquor Board had substantial evidence before it upon which to find that there was disturbance of the peace and to impose the fine imposed. They're without power to impose the other sanction, that is to prohibit the outside music. And this Court, of course, the Circuit Court owed no deference, and this Court owes no deference to the Board's decision, whether it was supported by substantial evidence or not on an issue of law. They had no legal authority to do what they did. I will tell you that the record does reveal, and to extract at 42, there's a specific statement by the chairman that the finding was with regard to the activities of July 1, 2007 only. And that's what they found to be the violation of disturbance of peace only on that date, based upon the testimony of, I believe, 3 or 4 nearby citizens. And they admit in the record, and of course it's in the record, that there was testimony from other neighbors nearby that it was not disturbing. The court made that decision, as I understand the law, even if the minds are in even balance, and probably even if the board, after hearing the evidence, thought that the respondent, the licensee's evidence was a little stronger, but they had support, they could probably find for these complaints. I think that's potentially that. I don't want to necessarily concede that here. I don't have to. May I go back to a couple of things, though, that Mr. Gaskins addressed. First off, I strongly disagree about this remand issue. The Baltimore County, neither the circuit court nor do I believe this court, with regard to Baltimore County, has the authority to remand. The provisions of Article 2B, Section 16101, the verbatim text of the statute as part of the brief at page 40 at the bottom indicates in 16101E4I.
Is E4, is that in the appendix or the record?
It's actually page 40 of the brief included as the verbatim text of the appellant's brief.
All right. I'm just.
And that's the verbatim text of 2B, Section 16101, page 40, and it's at E4I. It says, if the court reverses the action of the local licensing board, shall file with it papers and a written statement of the reasons. Then it goes on to say the court may modify as well as affirm or reverse the action of the local licensing board, and talks about costs. The next subsection, 2I, indicates, in addition to the other powers of the court provided in this article, the court may remand the proceedings to the local licensing board in the following jurisdictions. And then it lists 9 of them, which clearly exclude Baltimore County. And obviously the rest of the counties. So essentially, even though I understand in the way Article 2B, Section 16101, particularly this would be 41 of the brief, the verbatim text at F1 talks about, or I'm sorry, F2, that you may, if you've been a party to proceeding below, the appeal below, you could then appeal further to the Court of Special Appeals or upon certiorari to this court.
Has there ever been a case applying that statute where the appellate court
There
said,
have,
no,
and
we
I
can't
apologize that I cannot give you a cite on that right now. But there is case law that interprets where one can have remand and where there can't be remand. And I know it's something that the Court of Special Appeals occasionally grappled with because it's probably, I know at least in one case where Judge Eiler said, gee, wouldn't you like to give us the authority to remand back to the Baltimore County Board? It hasn't happened so far. The General Assembly, in its wisdom or lack of wisdom, has not done that thus far. This Court essentially, and I think the case law supports this, bears it out, is really reviewing the decision of the Board. Judge Bollinger's decision is only relevant as it's the conduit to get it here, and it's whether the Board acted lawfully. And I believe that's truly the issue here. So it's going to have to be, at least it's our contention, affirm, reverse, or modify. Now,
And what are our options about modifying?
well, that's a good question. I can't cite you to a lot of case law that indicates what the constraints on that are. And obviously, if this Court does it, I don't know that there's any place else I could go other than if it was something that the Supreme Court would take up because it had some sort of, federal constitutional implication. It seems to me that if this Court was going to do that, then it almost puts you in an original fact-finding position to say, well, we need to hear something now about your client, and we need to examine what the record says about what actually happened.
So could we remand it to the circuit court for such a hearing and determination?
The problem is, whatever the circuit court did, they couldn't remand it back to the local board.
I understand. That wasn't my question.
Maybe they can and maybe they can't. I know you're quoting the statute correctly, but it's not the only rule of law in play here. But at one point, when you were presenting your argument to the board, you said Mr. Thanner has, in fact, ceased having the outdoor music or entertainment of any type, and they don't broadcast any inside music to the outside either at this time.
And that was, there was Mr. Tanner in his testimony indicated that Councilman Oshevsky, who's the local county councilman for that area of Baltimore County, includes Miller's Island, where this tavern restaurant is situated, right on the Chesapeake Bay, which is part of the problem here. It's a wonderful place to be, and that's why some of the people that live there don't like this encroachment from this business that's been there since post-Prohibition. Not this particular one, but a previous incarnation. And honestly, as trial advocate for my client, I'm trying to suggest to the board why, not to do anything too disastrous. We have ceased at Councilman Oshevsky's request to do this for now.
Yeah, I'm not being critical of it. It's just the question arises. Let's say we were to affirm on technical, perhaps procedural grounds. Is there anything that would stop you from going back to the board at this point and ask the board to modify its prohibition against all outside music?
No. There's no question with, as long as they have the license, that we have the right to have that reviewed. And I will indicate that, by the way, the license has been applied for renewal and renewed twice since the time of this violation hearing, the last 2 license years. However, and there hasn't been an issue about that. And the board, of course, has not in that intervening time offered to reinstate the privilege. We could ask for that. The concern I have, frankly, is precedential in that sense. If we tell the board that, now, of course, I hope that this court wouldn't make that finding unless you believe that's the law, and we contend it's not. But the board then is going to think they can do that not only in this case, but every other case. And at any time they can prohibit that. And I believe they need to resort to the General Assembly for that power. And that's my real concern about that.
When they're given the power to regulate noise, what does that power encompass? And they're given that in the statute.
They are. And it says particular types of noise. And really interestingly, I probably should refer to that particular section. But
there's one interpretation might well be, I suppose, that you put a gloss on that ruling and you say no more outside music that would violate the particular section.
And as a practical matter, I think that would be fine. It would probably be redundant to the law because I think every time they disturb the peace, they subject to potential sanction. The problem is they didn't say that, though, Your Honor. They said no more outside music.
So we could modify that order and limit it to whatever.
Something that's disturbance to the public peace.
Yeah, something that is within their jurisdiction under the statute to regulate.
And it would put my client in a much different posture because that means there would have to at least be a fine and a threshold that is something that was disturbance to the peace. In the colloquy, I think, between Mr. Gaskins and I'm not sure it was Judge Barbera,
is it only disturbance of the peace that they can regulate noise?
Well, right now, the board has specifically said you're prohibited from having these mechanical type of music or whatever boxes after 11 p.m. unless it's not disturbing and it's inside. And that's the only rule they've adopted. So this is prior to that time. And the board said you can't have it at all. I don't care whether you do it at 3 p.m. in the afternoon or 6 p.m. or any other time.
Right, but I'm talking about the board's regulatory authority.
And that is exactly what the board has adopted at this point in time. And I think I'm done. But it would give me an opportunity to dispute whether or not there had been disturbance. Right now, we could be sanctioned just for having it.
Yeah. Wait a minute. She's got one final question.
Does the board, under the statute, and I had it in front of me a minute ago and stuck it somewhere, have the authority under A2 of Article 2B, Section 9201, which says they can regulate and limit the use of mechanical music boxes and other sound boxes, or they have also had authority to regulate noise.
Well, it's the board's rule that talked about the noise. The statute only allowed them to regulate and limit the use of mechanical music boxes or other sound-making devices.
Okay. Do they have to find, in accordance with their exercise of this jurisdiction under A2, that it was a public nuisance? Or can they just say, it is too loud for this neighborhood under these circumstances.
From a rulemaking standpoint, I think the board would have to adopt a rule that specifically says you can impose these particular type of response sanctions, or this is prohibited, this type of thing. Since, as Judge Murphy said, you cannot have any kind of musical presentation that disturbs the public peace, although I think that would probably be redundant to the existing law, both criminal and probably zoning provisions, et cetera. Part of the problem is that the board did not adopt such a rule, by the way. They only adopted a rule prohibiting these mechanical boxes. In which
Now,
they can
is there
play Zephyr
something in the
11
statute which directs that they adopt regulations in
Well,
order to regulate?
It doesn't direct, it says they may. It says they have the authority to do that.
Thank you.
Thank you.
Thank you both.
very much.
Number 115.